Good morning, Your Honors. I'm Robert Donald from Fort Myers. I'm here on behalf of the appellants, Ms. Lewis, Fox, Karis, and Hemmelgarn, which were referred to in the trial court as the first family, and I intend to use the same convention here. I'm opposed by Mark Anderson, also from Fort Myers, and he represents the other co-parsoners referred to as the second family. I would like to reserve 3 minutes for rebuttal, if I may. At the center of this case is a parcel of property with a home on it on the river in East Fort Myers. It was built long ago by a fellow named Frank Connor Ellis, who died in 1993. Mr. Connor Ellis had 2 wives and children by both. The first family, my people, are 4 of those children or their successors. The second family is 3 of those children by the second wife, and those are the 2 opposing sides here. After the death of the second wife in 2003, the first and second families became owners of the property in a co-tenancy. In 2004, they all agreed that they would list the property for sale and they would accept any offer that was $725,000 or more. There were such offers, but the second family rejected them. The bottom then fell out of the real estate market, and the property still has not been sold. Okay, 5 years then go by, and the second family filed a partition action against the first family, alleging that they all own the property in common, and asked the court to conduct a private sale or allow a private sale of the property. The first family counterclaimed for breach of the contract to sell the property that had occurred 5 years before. The counterclaim, because it was legal rather than equitable, was tried to a jury. The jury returned a sizable verdict for the first family. After the trial, the second family filed a motion for JNOV, which the trial court ultimately granted, finding that the first family's counterclaim was a permissive counterclaim rather than a compulsory one, and therefore was barred by the statute of limitations.
Let me just ask you about that here. You're arguing that, as I understand it, that the first family's counterclaim is a mandatory counterclaim so that it's not subject to the bar of the statute of limitations. And your opponent's arguing that it's a permissive counterclaim so that it was subject to the bar of the statute of limitations. So if you're right, and since the partition action hadn't been determined, there's an argument that we don't have jurisdiction because the matter's not final. If you're wrong, then we would have jurisdiction, but it would only be to rule against you. Is that correct?
Yeah, this is it's like the snake eating its tail or something. Here's the way I've thought about it. The trial court has held that it's a permissive counterclaim. Therefore, you have jurisdiction to review that finding. I would liken it to, you've got a final judgment and it's appealed, and because you have jurisdiction because it's a final judgment. But if you reverse, it's no longer a final judgment. So, I mean, it's the same kind of thing. This court has jurisdiction because the trial court has found that this was a permissive counterclaim rather than a compulsory one. We believe it was compulsory, and as you say, Judge Wallace, the ramifications of that is that we shouldn't be here now, but we are because of what the trial court found, and that's what gives you jurisdiction here.
Because it was permissive, the judgment she set aside was final.
Yes, I guess that.
Yeah.
I'll take your word for it. I'll go with that one, okay?
This is an odd situation.
Okay. So as you were saying, Judge Wallace, the issue here boils down to, was it a permissive counterclaim or compulsory counterclaim? This court reviews that de novo for 2 different reasons. The issue of whether a counterclaim is compulsory or permissive is a legal one that's reviewed de novo. Secondly, the trial court granted a JNOV, which is also reviewed de novo with all the facts and inferences in favor of the non-moving party. So this is one of those rare instances, like a summary judgment, where there's a de novo review on appeal with the presumptions in favor of the appellant rather than the appellee. The place we ought to start with this discussion is the Ali case decided by the Supreme Court in 1987, whereby it adopted the general rule called the recoupment rule that says the defendant can assert a counterclaim which standing alone would be barred by the statute of limitations, even if the counterclaim ends up yielding a positive judgment for the defendant. The only qualification being is that the counterclaim must be a compulsory one rather than a permissive one. We then go to how do we make the decision as to what's compulsory or permissive. Unfortunately, the rule, which was adopted by the Florida courts from the federal courts and traces all the way back to a 1926 U.S. Supreme Court decision, is vague. It sort of has some circular reasoning in it, and several decisions note that this is a real hard rule to apply, calling for a lot of judgment depending upon the facts of a particular case. The test boils down to is there must be a, quote, logical relationship, unquote, between the claim and the counterclaim. That's a pretty vague standard, and there's just no case that's literally on point or that even is really close that talks about this, but we're stuck with what we got. I would point out that the law favors construing counterclaims as compulsory rather than permissive when it's at all possible to do so. So this being said, let's turn our attention back here to the pleadings and the facts of this case. The first and second families own this property as tenants in common. There's only two ways to dissolve a tenancy in common. One is by the parties voluntarily agreeing to sell the property, and this is often termed a voluntary partition. And the second way is by seeking court intervention and in essence imposing an agreement upon the parties to sell the property, and this is a judicial partition. Going back to this case now, what we have here is the complaint and the counterclaim are essentially the two sides of the same coin. There's only two ways to get rid of property owned in co-tenancy. The plaintiffs, the second family in their complaint alleged they wanted judicial partition. The first family in its counterclaim alleges that there was a voluntary partition that the second family breached. So we've essentially got here the only two ways that co-tenancy can be terminated. The case law involving similar claims and counterclaims are not of great help, as I've said. I cited this Lockwood case from 1937, which frankly was before this permissive compulsory counterclaim was even an important issue. But what Lockwood says is it's appropriate in a partition action that any disputes among the co-partners should be resolved at the time of the partition action. So even though the issue was not exactly the same, the sentiment of Lockwood is supportive of our position.
Wouldn't that sort of be restricted to claims involving payment of taxes and improvements and receipt of rents and profits and that kind of thing, rather than the kind of claim that your clients made?
That was not the facts in Lockwood. As I recall, in Lockwood, it was a contract separate and apart from the partition. It was not settling up in the partition action. There were actually disputes between the co-tenants other than the partition itself. But again, I concede it did not deal with this compulsory permissive distinction. Judge Wallace, your decision in Maynard, I said I argued in the briefs that perhaps the best analogy would be a mortgage foreclosure action, and compulsory counterclaims and mortgage foreclosure actions, could shed some light on this, because mortgage foreclosure, like partition, involves real property. It's an equitable proceeding, so it's maybe as close as we're going to get. And what you held in the Maynard case is that a counterclaim for breach of contract and for breach of, or fraud, I think it was a compulsory counterclaim. Not, a case right on point, but I think the idea of Maynard is favorable to our position. The case that the trial court relied upon and that the second family relies upon is this Admiral Security case, which actually is the most interesting facet of this appeal, I think. Admiral Security was decided by the 4th DCA in 2001. It's a per curiam decision. It's a short decision. It doesn't say a whole lot, but what it does says is rather unusual. It talked about the recoupment rule, and it summarized the Rybovich exception to the recoupment rule. Now let's divert a little bit and talk about Rybovich. 4 years after adopting the recoupment rule in Ali, the Supreme Court of Florida made one exception to the recoupment rule, and that was in this case called Rybovich. In Rybovich, the main claim was for money damages, and the counterclaim was for specific performance in the sale of real property. Justice Kogan wrote the decision and pretty much said, gee, though the general rule, the recoupment rule is a good one, we're going to create an exception for specific performance of a contract to sell real estate, because their specific performance is a harsh remedy, it's not favored, and it screws up title to property. So if we allow a counterclaim for specific performance to be asserted irregardless or regardless of the statute of limitations, that it could be years later. So we create this exception in Rybovich that it doesn't apply when the counterclaim is for specific performance of real estate. Back to Admiral Security, which comes along in 2001. They cite, or the per curiam decision sets forth the facts of Rybovich and gets it exactly backwards. Okay, it says that in Rybovich the main claim was for specific performance. That's not true. It was the counterclaim in Rybovich. In other words, in Admiral Security, they got Rybovich exactly backwards. Okay, in Admiral Security, the claim was for quiet title. Okay, it wasn't even for specific performance. Yet the court said in Admiral Security, based on Rybovich, that the counterclaim for money damages could not stand against a quiet title complaint because of the Rybovich exception. It's rare that you see a decision that so blatantly gets it wrong. The 4th DCA here just fumbled the ball in looking at Rybovich. And Judge Wallace, your Maynard decision, where you got it right, you noted that Rybovich pertains to counterclaims and for specific performance of sale of real property. And if you take Admiral Security to its conclusion, it's contrary to Maynard. Either Admiral Security is right or you decided Maynard wrong, because Maynard was a mortgage foreclosure action, an equity action, just like in Admiral Security, the main claim was an equity action. Yet you found that compulsory counterclaims could stand under the general rule.
Here's the thing about Maynard was, when you're foreclosing a mortgage, you're asking, for an amount of money that's going to be either paid or come out of the sale of the property.
Yeah, that's true. well, you know, in a partition action, you get to money also. But Rybovich doesn't make the equity law distinction. There makes no distinction as to the main claim. In fact, the whole case is about the counterclaim. And that's the mistake that Admiral Security made. It transposed the two and looked at the main claim rather than the counterclaim. Here the counterclaim is for money damages. It's right in the sweet spot of the recoupment rule. There couldn't be a plainer case for the recoupment rule applying than a breach of contract action. It's a legal action to be tried by the jury. So if Admiral Security is wrong, how do you determine what's right? The way I analyze this is to try to figure out how our counterclaim meshes or doesn't mesh with like affirmative defenses. Recall this, the recoupment rule itself in Alley arises from an affirmative defense. Recoupament's an affirmative defense. In Alley, the Supreme Court broadened it to include counterclaims. But in the case itself, that is Alley, the court mentions affirmative defenses and counterclaims in the same sentence. How would this look as a counterclaim? In a partition action, you can raise estoppel as an affirmative defense, which we have done here, and we incorporate our counterclaim by reference into the affirmative defenses, okay? So the substance of our counterclaim also plays a role in the affirmative defenses, and it seems to me like this is a pretty good way of judging whether it's compulsory or permissive for purposes of the recoupment rule. Second way to look at it, which is somewhat related, is...
And I will tell you, Mr. Donald, you're down to your 3 minutes, so... How
about let's go one more.
All right.
Save 2. A second way of looking at this is consider it as a what happens if you consider it as a permissive counterclaim? Forget statute of limitation for a minute. You bring a partition action. It goes all the way through. There's a sale, property is distributed. Could the defendants in the partition action then later bring an action for breach of contract to sell the property? No, the court would say, hey, that was a compulsory counterclaim. You should have brought that in the partition action, which is the appropriate place, whether it's a voluntary or involuntary partition, to have those issues adjudicated. I'm going to cut short now because I'm almost out of time, but I'll reserve what time I have left for rebuttal. Thank you, Your Honors.
2.5 minutes.
May it please the court, my name is Mark Anderson. I represent the appellees, also referred to as the second family in this matter. The basic facts of this case are not in dispute, and so I don't think we need to spend a whole lot of time hashing those out for the purposes of this appeal. I do want to point out, and opposing counsel will not dispute that the first family, the appellants, filed an action for partition back in 2005. They filed a partition action that was not brought along with a breach of contract, even though they were aware of the alleged breach of contract by the appellees. This is important because this action for partition went pending for approximately 3 to 4 years until it was eventually dismissed for a lack of prosecution in 2009. A year later, my clients, the second family, brought their partition action for the same property, and this is the action that the case went to trial on and that we are now up against. So my clients filed a partition action for the subject property, and the first family then brought their answers, affirmative defenses, and counterclaims for breach of contract, breach of joint venture agreement, as well as a breach of fiduciary duty. It becomes important because they had the opportunity to bring their counterclaims, of which they were aware of back in 2005. They did not do so for whatever reason. It was not until after my clients had filed the partition action in 2010, over 5 years after they became aware of the alleged breach of contract. This appeal is really about the statute of limitations. Statute of limitations is there so that parties do not rest on their rights and wait to exercise those rights. And the first family relies on this theory of recoupment in order to try to get around this timeliness obligation. The recoupment creates an exception to the statute of limitations for parties bringing compulsory counterclaims, and that's really where the distinction becomes very important. Is this a compulsory counterclaim? Is it a permissive counterclaim? The recoupment does not apply here because the first family counterclaims are permissive, not compulsory. In addition, recoupment, which is essentially a set-off mechanism, has no application here because the claims that we brought were equitable. The partition action was one in equity, and theirs was for money damages. As opposing counsel stated, the general rule is from Alley. The rule of recoupment allows a party to raise a compulsory counterclaim that would otherwise be barred by the statute of limitations. It applies only in actions for money damages. In other words, recoupment cannot be used where the claim sought to be reduced by recoupment is not a money damages claim. And this is the situation that we have here. A partition action is the underlying action, is one in equity, and the counterclaims are based on money damages. In the Curtis case, as in this case, the claim was not for money damages, but it was distinctly an action regarding title to realty. Specifically, the second family's action was strictly for partition of the subject property, not for money damages. Thus, as a matter of law, the first family's counterclaims are barred by the statute of limitations, and the recoupment exception cannot save them in this case. I would just briefly recite Florida Rule Civil Procedure 1.170A, which discusses compulsory counterclaims and states that a pleading shall state as a counterclaim any claim which at the time of serving the pleading, the pleader has against any opposing party, provided it arises out of the transaction or occurrence that the subject matter of the opposing party's claim and does not require for its adjudication the presence of third parties over whom the court cannot acquire jurisdiction. And the seminal case is the Londono versus Turkey Creek case, which I'm sure the court is familiar with. The Supreme Court in Londono adopted the logical relationship test. The test is as such. A claim has a logical relationship to the original claim if it arises out of the same aggregate of operative facts as the original claims in two senses. That the same aggregate of operative facts serves as the basis of both claims, or that the aggregate core of facts upon which the original claim rests activates additional legal rights in a party defendant that would otherwise remain dormant. Now this becomes important. The main claim and the counterclaims do not share the same core of facts and law in this case. Just very briefly, the partition action, really there are three facts under Chapter 64. It identifies the subject property, it identifies the property's owners, and three, it states the property is indivisible and not subject to partition in kind without prejudice. Those are the three operative facts for partition action in this case. The first family's counterclaims, however, involve transactions and occurrences that go far, far outside the partition. And let me just list those. There has to be an offer by Christoph, who was the representative for the second family. An offer by Mr. Christoph to list the property for sale. 2, an alleged agreement to accept any offer over $725,000 or above. 3, an alleged oral acceptance by Lewis, who was the representative for the first family of these terms. 4, the terms of a listing agreement. 5, the receipt of one or more offers that met the $725,000 threshold. 6, the second family's alleged failure to notify the first family of the $730,000 offer prior to its expiration. 7, the second family's refusal to accept that offer of $730,000. And finally, number 8, the first family's alleged damages resulting from the purported breach. The list of facts that are necessary to establish the counterclaims go so far beyond the scope of the partition action. So as to the first prong of this logical relationship test, the operative facts giving rise to the partition action are completely distinct from those giving rise to the counterclaims for money damages. Much, much broader, the facts of the counterclaims. As to the second prong of the logical relationship test, the first family's rights related to the alleged breach of the contract were not dormant until the partition action came about. In fact, they were aware of it 5 years before the partition action was filed. They themselves filed a partition action on the subject property. The matter was litigated for some time in Lee County, and eventually it was dismissed for lack of prosecution. They were fully aware, and there is no evidence to indicate otherwise, that they were not aware of this alleged breach of contract until my clients, the second family, filed the partition action. Even if the court was to find that the counterclaims are compulsory, the exception to the recoupment rule established by Rybovich and Curtis bars recovery. The trial court, in this case, stated in the order granting the GNOV, in this case, the second family's petition is not one for money damages. Even if the counterclaim is determined to be compulsory, under Admiral versus Curtis, applying Rybovich, it is time barred. The court finds Rybovich and Curtis to be controlling in this case and finds the first family's counterclaims to be time barred and cannot be asserted as defensive claims. Now, Alley demonstrates the logical application of recoupment in a case in which both of the claims are for money damages, and that makes sense. You file a suit for money damages, the defendant files a recoupment defense, and you can set off and you can adjust the money. However, in this case, as with Rybovich and Curtis, the recoupment does not apply, whereas here, the claims and counterclaims do not both seek money damages. And in Rybovich, the Supreme Court held that the recoupment rule could not save an equitable counterclaim barred by the statute of limitations where the main claim was for money damages. And Curtis expressly held that the Rybovich exception to recoupment likewise applies in the reverse scenario, whereas in this case, the main claim is for equity and the counterclaim is for money damages. Now, Judge Wallace, you asked a question early on in opposing counsel's argument and asked about that and asked about the Maynard decision. And opposing counsel is trying to say that Maynard and Curtis are inconsistent. That is not the case. If you look at the facts of Maynard, it was in fact a foreclosure action along with a breach of promissory note. It was not strictly an equitable action. They were also seeking money damages against the mortgager. And so when the mortgager filed for recoupment, there was an ability by the court to set off, to adjust any money that the mortgage company was to recover. And so that is an important distinction. Maynard and Curtis are not inconsistent. In fact, they're very much consistent because in Maynard, the plaintiff was also seeking recovery damages under the foreclosure as well as the promissory note. If the court does not have any questions, I would respectfully request that that the order that is on appeal be affirmed. Thank you.
Thank you, Mr. Anderson.
Your Honors, the previous partition action filed by the first family, it wasn't mentioned in the answer brief. I'm not surprised Mr. Anderson mentions it because he did in the trial court below, but it's of absolutely no relevance to the recoupment rule. The recoupment rule is not based on what we knew or didn't know. That's not the basis of the recoupment rule. So that's sort of a red herring, the prior partition action, as the trial court itself essentially found by rejecting it. He also says that the recoupment rule essentially pertains to a set-off. That's not true either. Alley makes it clear that you can obtain an affirmative judgment. It's not a means of set-off. That's the whole purpose of the recoupment rule. it's interesting to note that he says that the main claim must be for money damages. Well, Alley itself, you know what the main claim was in Alley? I'm reading in here. Plaintiff sued for restitution and rescission, okay? This was not a claim for money damages. Even in the Alley case, it established the general rule. They also say that the facts of this case are the counterclaim is not exactly the same as the main claim. Of course, they never will be. And what I'd like to do is close by reading from Moore, which is the U.S. Supreme Court case that established this rule. And here, in Moore, the court said, quote, "It may comprehend a series of many occurrences depending not so much upon immediateness of their connection as upon their logical relationship. That they are not precisely identical or that the counterclaim embraces additional allegations is not relevant." And then quoting again, "To hold otherwise would be to rob this branch of the rule of all serviceable meaning, since the facts relied upon by the plaintiff rarely, if ever, are in all particulars the same as those constituting the defendant's counterclaim." The logical relationship arises from the whole schmeal, okay? It's not looking at the allegations of the complaint. They're opposite sides of the coin for getting rid of property owned by co-tenants. There's two ways to do it. The complaint and counterclaim each adopt one of those ways. It's hard to see that in a partition action how you could have a plainer compulsory counterclaim than this one is, okay? Thank you, Your Honors. Appreciate it.
Thank you both.